Audit them. Your favorite auditor, the one who encourages you to audit them. Testing, testing. Audit them. Your favorite auditor, the one who Yep. We are live. Alrighty. Hello there all. We are going to be going over Illinois Supreme Court rules. We are just focusing on the titles. We may open up some specific rules. Please bear with me here. Alrighty. Alrighty, here we go. Could you just confirm with me that you folks hear the audio and the video? Jenny, good to see you. As always. Alrighty, just waiting for a few people to get in here before we begin. Nothing in this session here is to be construed as legal advice. Don't try this at home. Well, is to be construed as audio is clear. Beautiful. So, Rule 1 is applicability, construction, rule-making procedures, citations, case and document accessibility. Today we're going over the Supreme Court rules of Illinois. We did look up in the past, we looked up the federal civil rules for the federal, and today we're focusing on Illinois state. So again, once we are finished going over some of these rules, we may also open up some of these actual writings as well, some of these amendments. So could you go ahead and please hit the thumb up and let me know that audio and video is clear here. And we'll go ahead and carry on. Okay, beautiful. So again, we have applicability, construction, rulemaking procedures, citations, case and document accessibility at number 8. Oh, wow. Electronic filing of documents. Okay, well, with that being said, we're going to look at case and document accessibility real quick. Just want to read this one real fast. Okay, let me zoom in here. Make sure you guys could see this on the screen. Rule 8, case and document accessibility. Section A, all cases and documents are presumed to be accessible by the court and clerk. Clerks shall limit access to case information and documents that are not identified as public to the clerk and or limited supervisory staff through the use of access codes restricting access. Access to court records and documents remotely over the internet shall be authorized by Illinois Supreme Court Remote Access Policy. Oh my God. Okay, Section B. Let me just highlight this real fast. Give me a second here, guys, before we continue. This should be relatively similar to your state, to your constitutional code. Alrighty. Section B, unless otherwise specified by rule, statute, or order of court, access to case information and documents maintained by the clerk are defined as follows. Number 1, public means a document or case that is accessible by any person upon request. Impounded means a document or case that is accessible only to the parties of the record on the case. Otherwise, the document or case is only accessible upon order of the court. Alrighty. Number 4. Sealed means a document or case that is accessible only upon order of court. Number 5, expunged means a document or case that is accessible only upon order of the court as provided in Section 52E of the Criminal Identification Act. Section C, notwithstanding the above, the court may enter an order restricting access to any case or document per order of court. Let me take a look here in the comments section. Oh, Blake, what up though, bro? You said you like my my song, if you're referring to as a bop. If we are eligible, we will have a music session after this reading here, if we are eligible. P.S. America's breaking down in real time. I addressed that in the song there. Yeah, it's burning up on both sides, all sides. But so here we are, and this is Supreme Court Rule 8. Alrighty, that was a quick one. So back on duty. And all immunity. Good to see you, bro. Gregory Lipsy. Good to see you guys. Blake, did you think that was a decent track that I released earlier? Did you like that? Alrighty. That was just a quick free flow. Rule 9, electronic filing in documents. Rule 10, size and specification of documents filed in Illinois courts. 11, manner or serving documents other than process and compliant on parties not in default, in trial, and reviewing courts. I got to put my deep voice in. I got to start putting in my deep voice. Rule 12, proof of service in trial. Proof of service in trial and reviewing courts, effective date and service. Appearances, time to plead, withdraw. Rule 13 is appearances, time to plead, withdraw. Accompanying Supreme Court forms, notice of limited scope appearance, notice of withdrawal of limited scope appearance, objection to withdrawal of limited scope appearance. Alrighty. Social Security numbers and pleadings and related matters. Rule 16 is certification instead of notarization. So I would just want to read that one real quick. That's a one-liner. That's a one take. Rule 16, certification instead of notarization. Any affidavit filed under oath in any court of the state may be made by certification set forth in Section 109 of the Illinois Civil Procedure. Okay, so this is saying certification instead of notarization. Well, they're not they're not claiming that you're unable to file a notarized. They're just saying if any affidavit filed under oath in any court under oath by certification set forth is to be complied with the statute 735 ILCS 51109. Okay, let's go ahead and continue here. We are at Rule 16, 17, foreign subpoenas. Subpoena someone from out of the country. Rule 18, findings of unconstitutionality. 19, notice of claim of unconstitutionality. Certification of questions of state law for certain federal courts. Rule 20. 21, circuit court rules and filings of rules. Administrative authority, general orders. Oh, wow. Click that one real quick. Yeah, Blake, like I said, yep, I will probably be on right after this, bro. We're going to zip through this one here. That's a two-pager there. Rule 22, appellate court organization, administrative authority, appellate court rules. Rule 23, deposition or disposition of cases in appellate court. Research department in each district of appellate court. Let me click on that bad boy real quick. Rule 24. Okay, let me just highlight this one real quick. Rule 24, research department in each district of Illinois Appellate Court. Let me zoom in. In each appellate court district shall be a research department supervised by a director of research and staffed by such number of staff attorneys, and Supreme Court may from time to time determine the research departments in each district shall perform such duties as may to be assigned to it by the presiding judge of the district, or in the first district. Let's see. Activities, exchange information in public, and publish and maintain a manual of procedures for research staff. An assistant to the Supreme Court may be assigned by the court to coordinate activities of research departments hereby created. The director of research and all staff attorneys employed in the research department shall be graduates of law schools approved by the American Bar Association. Okay, let me go ahead and take a screenshot of that one. Let's see. Sorry guys, we're gonna flicker right through them. I know it says titles only, so let's go ahead and continue. Alrighty. Oh, you know what? I should go ahead and put some soothing background music here. Cat in the background keeps bugging. Okay, let's see. Alrighty. So now we have Rule 30th, Administrative Duties of Chief Justice and Administrative Director. Rule 31, Seniority in the Supreme Court. Library of the Supreme Court. Ooh-wee. Appointment of Associate Judges. Marriage and Civil Union Divisions. Judicial Conference. Conference of Chief Circuit Judges. Lawyer's Assistant Program. Photography and Video in Courtroom. Ooh-wee. Remote Appearances in Circuit Court Proceedings. Official Record of Court Proceedings. Number 46. 56. Temporary assignment to other duties. Judicial performance evaluation. Violation of the rules at Rule 71. 76 is military service of judges. Mandatory arbitration. Introductory comments. What rule number is that? Well, 86 is action subject to mandatory arbitration. Hey, Nate, how's it going? Alrighty. Appointment, qualification, and compensation of arbitrators. Rule 88 is scheduling of hearings. Oh, that should be read to later time. Discoveries at 89. Real quick, let's click on schedule of hearing. I want to see how many pages. It's a one-pager. No audio. Real quick, let's click on. There is audio, bro. There is audio. Tennessee, how's it going? So that's a one-pager right there. And now let's click on discovery. Is also a one-pager. Good. Go ahead and continue. So we have discovery at rule number 89. Rule 90 is a notice or conduct of hearings. 91 is absence of party at hearing. Award and judgment on award. Oh, that got to be read too. Rejection of award. Oh, wow. Form of oath award and notice of award. Form of notice of rejection of award, Rule 95. Meditation program is at Rule 99. Mortgage foreclosure meditation program is at Rule 99.1. And at 101, implementation of expedited child support system. Appointment, qualification, and compensation of administrative hearing officers at 100.2. 100.3 is action subject to expedited child support hearings. Authority of administrative hearing officers. Blood tests is at Rule 105. Schedule of hearings 106. Conduct of hearing 7. Absence of party hearing 8. Transfers of judicial hearings. Submission of recommendations to courts. Let me put my deep voice here. No, we don't need no trolls. I don't think he's a troll. End all immunity. I don't think he's a troll. He might not could hear. If you could, please confirm with me. Press 1. Rule 111. Authority retained by the court. Judicial hearings. Definitions at Rule 13. 101. Rule 101. Summons and original process. Forms and issuance. Service of summons and complaint. Return. Service of summons and order in protective order proceedings. Alias summons, dismissal of lack of due diligence. 104. Service of pleadings and other papers, filings. Additional relief against parties in default, notice. Rule 105. 106. Notice of petitions filed for relief from or revival judgment. Alrighty. Explanation of rights of heirs and what's that? Legatees when will admitted or denied probate, if I'm pronouncing that correctly. 109. Reserved. 110. Explanation of rights in independent administration form of petition to terminate. Rule 113. Practice and procedure in mortgage foreclosure. Before we continue, let me click on well, let's continue. Alrighty, let's see what else we have here. Loss mitigation affidavit 114. Form of documents at 131. Form of documents. Let me just do a quick scan on this one here. Form of documents is a 1-pager. Alrighty, name. Oh yeah, simple. Alrighty. Well, let me see what this says here. All documents filed, served, in any cause by self-represented litigant upon a party shall bear self-represented litigant's mailing address and additionally who email and designate a single email address under rule. If a litigant does not designate email address, alrighty, never mind. It'll zip right through it. Alrighty, let's see here now. We are at number 132, designation of cases. Number 133, pleadings, breach of statutory duty, judgment or order, breach of condition precedent. 134, incorporation of pleadings by reference, pleading equitable matters at 135. 136 is denials. 137 is signing of pleadings, motions, and other papers, sanctions. Click on denial real quick. 136. 136 denial is a 1-pager. Alrighty, let's go ahead and continue here. Signing of pleadings, motions, and other papers, sanctions. Personal identity information is at 138. At 139, we have practice and procedure in eviction cases. Rule 181, appearances, answers, motions. 182, time for pleadings and motions other than those directed to complaint. Extension of time at Rule 183. Hearings on motion 184. Motions on ground of forum non convenes. Rules 188 and 19 through 190 reserved. Rule 191. Proceedings under section 1005 to 619 and 2301 of the Code of Procedure. Oh, wait a minute. Let me see this. Oh, let me see this. Alrighty, I needed this one. So let me go ahead and let me print this one out, guys. Give me a second here. Let me plug this cord up. Let's see. This is a necessary essential. This is a necessary essential. Essential. Necessary essential. Alrighty, let me go ahead and print this 2-pager here. Meanwhile, how's everybody hanging in there? Let me just print this out. Hey, Metal's on duty. Metal heard from the birds tweeting that I may be doing a music session after this, so he came by with his Esquire pencil. Canon MF. Alrighty. FOIA readings. Indeed. Indeed. This is not a FOIA reading. This is rules of the Supreme Court here. Alrighty, just had to print out that episode. Now let me go ahead and put that episode in this binder. Put that episode in this binder here, nice and organized, beautiful. Let's go ahead and carry on. We'll address that later. Alrighty. Rule 199, how cute. 191. Alright. Moving along. Rule 192, summary judgment, multiple issues. Rule 201, general discovery provisions, purpose for which dispositions may be taken in pleading action and pending action. Rule 202. Rule 203 is where depositions may be taken. Compelling appearance of deponent. Persons before whom depositions being deposed may be taken. Method of taking depositions on oral examination. Methods of taking depositions on oral examination. Signing and filing depositions. Fees and charges copies under Rule 208. Just take a quick glance. Quick glance. Alrighty, that's a 2-pager. Beautiful. Alrighty. Failure to attend or serve. That's a frightening one. Failure to attend. Let's just say attend, right? If a party serving notice of the taking of a deposition fails, this applies to deposition, so we'll get that at a later time. Failure to attend. Okay, depositions on written questions. 210. 211, effects of errors and irregularities in depositions, objections. Use of depositions at Rule 212. Written interrogatories to parties at Rule 213. Rule 214 is discovery of documents, objects, and tangible things, inspection of real estate. 215 is physical and mental examination of parties and other persons. 216, admission of fact or of what's this? Genesis of genesis of documents. Rule 217, depositions for the purpose of perpetrating testimony. Pretrial procedure, consequences of refusal to comply with rules or order relating to discovery at 219. And here at 222 we have limited and simplified discovery in certain cases. Rule 224 is discovery before suit to identify responsible persons and entities. Motion for continuance at Rule 231. Trial or equitable and legal matters. Parties over proceedings. Void your examination of jurors and cautionary instructions at Rule 234. Opening statements, 235. Wow, opening statements. Alrighty, a jury. Alrighty. Rule 235, opening statements. 236, admission of business records and evidence. 237, compelling appearance of witness at trial. 238, impeachment of witness, hostile witness. 239, instructions, directed verdicts, use of conference technology in civil cases, use of remote jury selection in civil cases, written juror questions directed to witness, orders of motions. 271, 272. There's about 700 of these guys. We're only at we're only at half of this right here. We got 700. We got about 500 of these to go here. There's about 700 rules here in the Illinois Supreme Court. Remember, keyword, laws. Oh, I meant rules. Okay, but anyhow, applicability at 280, definitions for credit card or debt buyer collection actions. Complaint in credit card or debt buyer collection action. Continuance of trial or voluntary dismissal of credit card or debt buyer, consequences for non-compliance, identity theft relating to credit card or buyer collection actions, definition of small claim. At 281, commencement of action, representation of corporations. At 282, seems like a good one. Commencement of action. Alrighty, so let's see what else we have here. Service by certified or registered mail, jury demands, appearance and trial, depositions, discovery and motions, installment payment of judgments. At 288. 289, service of process in proceedings to confirm a judgment by confession or to collect a judgment for $10,000 or less. 291, proceedings under the administrative review law. 292, form of summons in proceedings to review orders of the Illinois Workers' Compensation. Jury trial and voluntary admission proceedings. You better cut it out, Tifel. 294, disqualifications of lawyer serving in collaborative process and lawyers associated law firm. At 294. 293 is jury trial and involuntary admission proceeding. 295, matters assignable to associate judges. 296, use of restraints in court proceedings under the Mental Health and Developmental Disabilities Code. 298, application for waiver of court fees. 299, compensation for attorneys appointed to represent indigent parties. And Rule 300 is reserved. Beautiful. So like I said, guys, there's about 700 rules. We're just going to flicker through 1/3. We will pick this session up at a later time here. We came on for about a good 30 minutes. So it took about a minute per 100 rule, or 10 rule, whatever. But anyhow, we will pick this up at a later time, and we will be going into some of these actual writings here, some of these rules in depth, like we did earlier. So with that being said, thank you guys all for coming in. We have to keep on advancing our knowledge. We have to keep informing each other of what's going on. Supreme Court rules, state laws. We have to know how to handle our affairs. We can't keep depending on someone who, may not, nobody basically cares like you should. You should care for your own affair. So with that being said, stay tuned. I may be, keyword maybe, opening up a session after this. The one who encourages you to audit them.